Namuhla ke bekunene sibungata i-Day of Reconciliation. Lolu kelisuku lekubuyisana sibahlali baseNingizimu Afrika. Indzebe ke yemhlaba i-Rugby World Cup isibonisile ukuthi ukubuyisana kungaba yinto lenhle kanganani. Kepha ke sengase kubudlelwane bebasebenzi nebaqashi babo busakhungathwe bumadima ekubuyisaneni. Sikhuluma ke banyenti ke basebenzi labaqoshiwe emisebenzini ngekungavisani nebaqashi babo. Kanzi ke njengoba ke labanyenti batawube batijabulisa ngaKhisimusi kusenza kehlela ke kulabo kubo nemindeni yabo. Mina ke ngingisimphiwe Ngcongwane kanti ke leli Yilungelo Lakho asingene endzabeni yethu namhla. Baba Samson Sithole wasethembisa eJozi ngilomunye kwethi sebenzi kuleli ke letikhala ngekuphathwa ngesenqele ngumcashi wakhe. Uthi ke waxoshwa ke ngalokungekho emthethweni emsebenzini eminyakeni lophelile. Kanti ke nelithemba lokuthi ke lendzaba yakhe itawusombululeka iyashabalala ngoba imitamo yekungenela ke kwe-CCMA kuphelele ke emoyeni. Asisive ke indzaba yakhe.
Bengisebenza lapha as a driver. So mina ngivuke kahle ekseni ngaye emsebenzini ngasuka ngahamba ngayenza ama collections. Njengoba supervisor bekanginikeze umsebenzi wami umele onguyenza every day. Ngahamba ngayenza ama collection. Mangise site ngiyenza ama collection. Supervisor wangifonela wathi Babu Sithole kunama negotiation la emsebenzini we union and a company and ngathi they don't reach agreement. So ngicela ukuthi uphephe mawubuye supervisor yami leyo.
Babe Sithole uthi wasebenta lonke lelo langa kwade kwefika isikhathi sekushayisa.
Ekseni ngavuka kahle ngesikhathi ngaye emsebenzini. Mangifihle emsebenzini ngithola bonke labasebenzi laba bamegedini. Ngaqala ukubuza ukuthi madoda kwenzakalani. But hayi umlungu azwananga izolo usikhiphile uloke amagate company. For the whole week besiloko siye emsebenzini njengo normal days siloko sihlala ngaphandle.
Uthi bamangala kabi sebatfola tincwadzi leti batisa ukuthi baqoshiwe. Sebabonke labasebenzi bangu-104. Inkampani iphendvule yathi letisebenzi tatibandzakanya esitelekeni lesingekho emthethweni. Kanzi futhi lenkampani yathatha inyathelo letifanele kubuyisana nalabasebenzi kanye nekucatulula loludzaba.
Was it an illegal strike?
There was no one on strike. There was no one who was on strike. Because people, I believe, Baban striking, Patshwara the sticks, they go up and down chanting in front of the company, but no one who did it. Some of us, we feel that a company is failing. But I remember myself individually, I wrote my manager a letter. I sent a letter to them. I'm sorry for what happened. Maybe there's a misunderstanding. But because I wasn't part of what was happening. I told the SMS from the company, but we are busy sending the company, the MD of the company letters of apologies. The decision that's been taken by the company was final.
Ngekusitwa ngummeli ludzaba lwalabasebenzi lwendluliselwa e-CCMA.
Yo, CCMA, don't talk about CCMA. CCMA nowadays, we've got a big problem. Hundreds of people. And most of the award that they got from CCMA, they refer them to labor court. They know exactly we are poor. We can't afford.
Babe Sithole uthi lolu dzaba lwabo lutawuviwa e-labor court ngaNovember kulomnyaka lotako.
By that.
Life is difficult because we can't even pay school fees for our kids. We can't buy groceries in the house. A father like me, just imagine, they expect something from me as a father. I'm living on my wife's salary at the moment, and it's very difficult. My wife, she doesn't sleep at house anymore. She's always at work, trying to cover overtime so that she can look after us. And it's very difficult. The bond house, we need to pay. We need to pay the house. We can't. Now it's December again. That's why we are trying our level best to at least so long because we still got a pending case. Court should decide. If court decide, is then I can stop a pay. I can stop a pay whereas there's a pending case.
Nyalo-ke ukukhuluma kabanti ngendzaba yebumadima kubuyisana kwetisebenti-ke nebacashi babo. Asisimukele-ke Angelo Mason lovela-ke Mason Attorneys. Etinkundleni tethu tekusakata-ke eCape Town eKapa sina Matthew Parks yena-ke umelele ikhosathu. Kanti-ke bekunene angichaze ukuthi besimemile-ke ne-CCMA kepha-ke bathi and I quote emagameni abo, unfortunately there is no one available at that time and therefore the CCMA will not be able to participate. Ngemagama-ke CCMA leyo nasiceza kubamema. All right, gentlemen, a very good afternoon. Thank you so much for joining us, Mr. Parks in Cape Town, and Mr. Mason. Thank you so much for joining us.
Good afternoon.
I'm going to start with you, Mason. I'm sure you were listening to the plight of Mr. Sithole, and I guess it's just a reflection of the millions of South African workers who go through, these untenable conditions at work. What's your response?
Look, I can be able to give my sense in terms of what the disputes would be about. The person that's dealing with this particular matter is an associate of mine called Mr. Rampila from Tsepiso Rampila from Rampila Attorneys. The sense that we are saying is that what we experience at the CCMA and as well as the employees' experience at the CCMA, one can be able to get a sense that a little is done or something is done or a little is not done.
Yes.
So that is the sense that we are getting as practitioners as well. But we can be able to say that, your experience with a particular commissioner at the CCMA, one cannot I can only give an expression as to my experience with the commissioner. But the sense that other employees are facing with the commissioner, I cannot be able to give a sense with regard to that.
Okay, so do you think there is a culture of reconciliation between the labor movement, between workers and employers?
Look, we are saying that there must be, we can be able to say, if one gives regard to the Labor Relations Act, 28 of 1956, and you give the current Labor Relations Act, 66 of 1995, there's a provision in the labor relations, in the previous legislation, which has been repealed, which gives the workers a sense of getting a remuneration. That will be section 43 of that legislation, which will give a legislation, which will give the employee a sense of remuneration during the period when litigation is still ongoing. The current legislation doesn't give provision to that. Where a person is currently facing a litigation, the old act normally gives a person a wage, and it's upon that the person can see the matter to its finality. Yeah. The current legislation, where you only get with regard to the reinstatement, you'll only get back pay, and that is running the process. You will not be able to like Mr. Sithole, have a situation where you have a contract with the bank will foreclose against your property, and those type of things. Mm-hmm. So there's no redress as you litigate. There's no redress. In that regard, yeah.
All right. Mr. Matthew Parks in Cape Town, let me bring you into this conversation. Today, we're commemorating the Day of Reconciliation in South Africa, but do you want to paint us a picture of the labor climate in South Africa in general and the relationship between employers and employees?
Okay. Good afternoon. Thank you for having me. Look, it depends on the different types of sectors. In the public sector and many other sectors, by and large, things are okay. But in the sectors where most of the most vulnerable exploited workers work, like the retail, the farm, food, agriculture, mining, fuel, transport industries, things are quite bad. That's where workers are heavily exploited. That's where you have employers who both deliberately and also out of ignorance often ignore the laws completely. We've got about 6 major labor laws in the country. The labor relations, the basic conditions of employment, the unemployment insurance, 2 health and safety laws, 1 law dealing with farm workers, and often most of those progressive rights in those acts are simply ignored by employers. You also have a challenge where most workers are actually not aware of those acts or the specific technicalities of what are the specific provisions of those acts or how to enforce them. You also find a situation where the government, the Department of Labour's inspectors often are too few or don't actively, proactively enforce those laws. Workers often do go to the CCMA, but then again there what happens there is that the employer, if the decision is made against the employers go to labour courts to appeal it. And their workers get frustrated because it takes about 2 years to see your case through the labour courts. It's very expensive. Most workers can't afford to hire lawyers, and therefore most workers' rights just fall by the wayside. So the situation is quite bad, especially for those vulnerable workers on the ground.
And we've heard so many employees, millions of employees actually saying that the CCMA isn't helping them in any way. I mean, you speak of exploitation of workers, you speak on the violation of workers' rights. So in what way are workers exploited, just so we have a clearer picture, and what are some of these rights that have been violated by employers?
Sure. So, for example, we have a new National Minimum Wage Act since the beginning of January this year. There's been over 8,500 cases of non-payment of the minimum wage to the CCMA so far. And that's just tip of the iceberg. There are many other thousands of workers who are not being paid the minimum wage. You've got a Mining Health and Safety Act, which guarantees mine workers the right to work in a safe environment. But time and again, we see mine workers dying every week, and the employers are not being held accountable. Workers are entitled to 21 days paid off annual leave each year, but often in the retail sector, workers are too afraid to exercise that leave because they'll lose their job. There was a Labour amendment to the Labour Relations Act a few years ago to guarantee workers that they're permanent after 3 months of work. Often you don't have that. So especially in the retail sector, we've got cashiers and the big retailers who are on contract forever, often through outsourced labour brokers. You've got workers workers are guaranteed not to work beyond 48 hours a week. But time and again in the retail and the fuel and the transport sectors, workers are working 75, 80 hours a week, above the overtime threshold, and even then are not being paid overtime pay. So there's a whole raft of benefits workers are not receiving, and they go beyond that. They go to maternity leave, to paternity leave, and so on. So really it's a huge challenge between employers who either don't know about the laws or who choose to ignore it, and also equally workers themselves who are not aware of all the laws because of a lack of education by the department, by the CCMA, by even trade unions themselves. So it really is a huge challenge.
All right, we'll leave it there for now, Mr. Parks. We'll certainly continue our conversation after the break. And we wish the CCMA was here to clarify some of the issues for us, but unfortunately they could not be, or they couldn't join us. This is your right, Yilungelo Lakho. As we commemorate the Day of Reconciliation today, ucaba ukuthi khona yini ukubuyisana emkhatsini wethu nebaqashi babo? What are some of the problems that you have experienced? Sishayela ucingo ku 011 714 6918 noma ke 011 714 6919. Ungasithumela futhi ne-SMS ku 33721 noma ke usibhalile ku Facebook. All right, Mr. Mason, we continue with this conversation. I mean, how can workers be protected or cushioned against any injustices meted out by the employees?
Well, we can be able to say that there are bodies like the CCMA where the workers can be able to refer their dispute to the CCMA. And after referring the dispute to the CCMA, you can be able to then approach, there are certain instances where attorneys are not allowed to represent employees at the CCMA. That would be where the matters consisting of incapacity, misconduct, and poor work performance. Okay. Those instances where the employee has to ensure that the employer, where there is a situation where the employee, legal representative needs to make submissions to the CCMA, whether he can be allowed to be in the proceedings.
Okay.
Yes.
All right, let's take our first caller. We've got an anonymous caller from Potchefstroom.
Hello, how are you, sir?
All right, how are you?
I'm fine. I've got a coaching name. I was fired. There was a company that I used to work for in Rustenburg.
Okay.
I was fired on the 28th of November. This guy wanted to use my personal car for the work purpose. And then I...
Come again, he wanted to use your car?
Yeah, he wanted to use my private car for the work purpose.
Okay.
And he even told me that I'm disabled, he cannot work with a person with disability. And then when I opened a grievance against him, I was charged and then suspended with immediate effect. And then on the 28th of November, I was dismissed. At work. I wanted to protect this guy. This white guy wanted to use my own private car for the work people. And then when I can't use it because on my letter of appointment is not stated there. And I said, and then I was suspended and then being dismissed.
Whoa.
And then he even said to me that he cannot work with someone with a disability. I've got him on record. And then I went to CCMA and they said that they cannot enter my case. I need to pay to labor court.
All right, Anonymous, thank you so much. I'm so sorry to hear that. Well, our guest might help you out on that. I'm sure you've just heard the caller. He was dismissed and he was forced to use his own private car for work errands. I mean, this is a reality that's facing so many South Africans.
Well, I don't understand the question where he's using his own private car for working errands. I mean, one can be able to, I get a sense that if he had used the employer's resources to do his work errands and he then utilized the employer's car to do his own errands, I think then one can be able to say that there's an unfair dismissal there, because during the time that he's using the employer's car, whether it is
Well, my understanding is that he was forced to use his own personal car to do errands of of the employer.
Yes.
Yeah. So that's basically what he says.
So if he was doing errands for the employer, it would also determine as to whether the errands that he was doing was work-related errands. So if the employer then dismisses him regarding that, he can refer dismissal to unfair dismissal to the CCMA.
But then, is he supposed to use his own personal car to do errands of his employer?
You see, in terms of you need to.
What does the law say about it?
Well, with regard to using your own vehicle to do working errands, that would be well. I would not have an expression with regard to that, whether the law provides you to use your own errands to do the work, to do the employer's work. But what one can say is that there must be recourse with regard to that.
Okay, so in terms of the recourse that is available at his disposal, what's the next remedy? I mean, he says he's got a disability, and the employer said he can't work with people with a disability, and he's now sitting at home.
Well, you see, in terms of referring a matter, it also there's a matter that one can refer to as an unfair discrimination matter. At the CCMA, it depends on his threshold in terms of how much is he earning. If he earns per annum above below the threshold of 205 per annum, he can refer unfair discrimination matter based on his disability to the CCMA. There is in terms of utilizing the Employment Equity Act in terms of Section 10 of the Employment Equity Act.
Okay. Mr. Parks, let me also bring you into this conversation. I mean, we've heard an anonymous caller who say that he was fired because he defied his employer. He did not want to use his own private car to carry out errands of his employer. And he was also fired because the employer ostensibly said that he does not want to work with people with a disability. Just how prevalent are such issues in South Africa, workers being discriminated on the basis of their disability?
It's extremely prevalent. And look, he should report it to the CCMA, and if he's not successful there, to go to the Labour Court. He would win it. It's against the law to discriminate against somebody based on the disability. That's very clear. And then equally, if there's no provision in his contract about having to have his own car for work purposes, he'll win that case as well. So the important point is for him to take it up to CCMA and to the Labour Court if needs be. And look, these kind of discriminations are frequent. That's why you find the levels of employment of persons with disability are so low. It's below 1%. Most of those with disabilities who are employed are actually employed in government, and then even then are employed in kind of generally a few positions only, like call centers and those kind of things. So the levels of employment for persons with disability are extremely low. It's estimated that about 10% of the nation is consisting of persons with disabilities, yet only 1% of those persons are actually employed. The challenges there are around access to education, access to transport, employers being willing to employ such persons, and really a generally unhospitable environment. So it really is an indictment upon us as a nation, from government to employers to society at large, that we're not actually actively supporting the employment of those persons. But look, people need to be assertive and to fight for their rights. That's the only way we'll move the nation forward at large.
What's the success rate, though, of such cases, those who've been launching cases against their employers who are unfairly dismissed because of their disability?
But the huge disjuncture is that in the CCMA, workers are usually successful with regards to winning their cases, by and large. The challenge is that the employers then go to take it to the labour court, because employers have got money, they've got friends who are lawyers, they can afford to drag out the case in the labour court for 2 years. And workers don't have the money to hire lawyers, they're not aware of the full rights, and the 2-year-long process is emotionally exhausting for workers. So that's the huge disjuncture. What's needed there really is to amend the labour laws, to make the CCMA findings binding and immediately implementable, while still allowing people to appeal to the labour court. But the point is we have to get those decisions of the CCMA to be enforced immediately, be it around dismissals or unfair discrimination or health and safety violations, sexual harassments, the denial of workers' due wages, like the minimum wage and so on. They have to be enforced immediately. So we are working now with the government and the CCMA and Parliament about amending the labour relation, the BCA right now, through an amendment to the Minimum Wage Act to make the CCMA decisions binding, because the current scenario really discriminates against workers. It frustrates them because there is no worker who really, by and large, can afford to go to the labour court route.
All right, let's leave it there for now. We'll certainly discuss this further after the break. And siphinde senikhumbuze ke bekunene ukuthi ke simemile ke i-CCMA kepha ke ngelishwa abakakhoni kufika, and CCMA is just equally central to this discussion. Yilungelo Lakho, asathe linye likhefu. Asinamukele futhi ke bekunene. Please give us a call to share your experiences with taking your case to the CCMA. Our participation lines are still open and the numbers are on your screens right now. 011-714-6918 or 011-714-6919. Ungasithumela futhi ne-SMS ku 33721 noma ke usibhalele ku Facebook. Let's take our next caller. Sina Anonymous futhi ulapha ke eVaal. Sakumele hleleni sawubona.
Amen.
Anonymous caller from Vaal.
Hello, sir, how are you?
Fine, how are you?
I'm fine, thank you.
Great stuff. What's in your mind? Talk to us.
I have a problem here, sir. I was working for our company. It was a cash loan, and I used to be a teller there. I started working in 2017, and I decided to tell my employer that I am pregnant in 2018, in October. But to my surprise, I was then dismissed just like that in November, the same last year, in 2018. I went to the CCMA and I reported my case. It took a long time, about 4 months, until my case was heard earlier this year in April. And then after that, I was told to bring my papers to my employer. And then after that, I was only paid 4,400. After that, my employer did not say anything. She did not say anything at all. That was how I was fired. So I don't understand what's going on, because every time I had a situation, I would go and talk to her. She seemed like she was someone who would understand me, but she didn't. To me, I saw that she didn't follow any rules, because if I had any complaints, she wouldn't want us to listen to us. She just wanted to say what she wanted and we would listen to her. So I was fired because of that, because I was pregnant.
So is that what your employer says? What's the reasoning for dismissing you?
No, they say it was poor performance, but it's not that. When I went to the CCMA and reported my case, the CCMA told me that it's not poor performance, it's that you are pregnant. So we are going to call your employer. My employer dragged the case for 4 months. She didn't answer her call, she didn't do anything. I don't know what scared her to a point where she actually decided to come and show her face at CCMA and told them what happened.
Were you a contract worker or permanently employed?
I was a contract worker. My contract was supposed to expire late last year.
All right, Anonymous, thank you so much for your call. Mr. Mason, how would you respond to that?
Look, and I want to bring this to the question, a question to the table, is that the characterization of a dispute. Courts have already mentioned, the Constitutional Court in several cases in labeling your dispute, the courts have given indication that what label you attach to a particular dispute, one needs to look at the underlying problem or diagnosing the problem of the dispute. So you can label a dispute of constructive dismissal, but you can find it's unfair discrimination relating to pregnancy. So it depends on what label you put to the dispute. It's not, the commissioners are then supposed to then look at the facts instead of, and given the powers to investigate what the true fact, what the true nature of the dispute is, instead of putting labels to the dispute.
But in Anonymous' case, do you think she was unfairly dismissed because of her pregnancy? Well, she claims it's because of that, but the employer says it's poor performance.
No, that's why what I'm bringing the question back to you is that the labeling of the dispute, the forms, the CCMA forms wants you to characterize the dispute when you get dismissed. Therefore, the Constitutional Court in the case of if one can just draw one case of Kusa versus Theo Metal Industries, and the case of September, the September case and others, where the Constitutional Court says that by merely labeling the parties, labeling the dispute as you cannot, by the mere labeling of the dispute, one can be able to, the commissioner has to investigate and has the powers to investigate what the true nature of the dispute is. So if you refer the matter to the CCMA as poor work performance, you can find the underlying problem is that the matter is about unfair discrimination. So you would then say it's constructive dismissal, but then it relates to unfair discrimination in terms of pregnancy, in terms of Section 10 of the Employment Equity Act.
Okay. Now, Mr. Parks, the issue of unfair discrimination is popping up again. We've just had a caller, an anonymous caller from Val, saying that she was fired because she notified her employer that she was pregnant. Yet, on the other hand, the employer says she was dismissed because of poor performance. We may not know the merits of this case. So, is this a case that's been or that's familiar to you?
I wish that the lady would contact me afterwards. On face value, it looks like she was being violated in 3, possibly 4 areas. One is that it looks like she was not taken through a proper disciplinary process as required by the Labour Relations Act, where she should have been counselled if there's any issue of poor performance, given a first warning, second and third warnings. It appears that is not done. It appears that she really is being a victim of unfair discrimination based upon being a woman, being pregnant and so on, which is against the law. And of course, that the amount of money that was given to her, the 4,000 Rand, was far below what was meant to have been paid for her, given her length of service, the delays in having from when she was dismissed to the final finding of the CCMA. She should have been paid the back wages due to her, which was several months. And look, really, that employee should be taken to the cleaners. That's part of the problem we've highlighted earlier, was that the CCMA makes findings in favour of the workers, and the employer simply ignores it or goes to the Labour Court where he knows or she knows that they can frustrate the worker into giving up. And that's part of why we need to amend the laws to make the CCMA's decisions final and binding, and that they're immediately implementable. The other area where this worker might have been violated is that she says she was on contract, yet she's been working for more than 2 years. So that's far beyond the 3-month limitation upon contract work. She actually should have been a permanent employee and then given much greater protections as a worker.
And I guess that's a big issue. I mean, speaking of discrimination, and I want us to discuss the issue of contract work. Some of the companies, they claim that some of the projects that they're working on are not long-term projects, are short-term projects. Hence, they give workers short-term contracts. So is there some justification in this?
It depends on the type of work. In a construction site, sure, you're building one building which will take 3 months or 6 months and so on. There's some cases in the agricultural sector where you only need to hire workers to pick your grapes for 2 months, for example. That's not permanent work. Or you're hiring a driver just to transport one good and that's it. But this lady here is a cashier. She's working at one of these kind of debt or financial services companies. That's permanent work. You've got workers who work at ShopRite or Pick n Pay or other retailers, for example. It's permanent work. There are cashiers, there are shelf packers, there are cleaners, there are security guard. There's permanent work that the company needs permanently. They work for that company for years on end, but they are what you call permanent casual workers. They're given 3-month, 6-month contracts, which are just renewed all the time. It means they're stripped of many of the labor relations protections that they're entitled to, and also they don't enjoy the full benefits of ordinary workers would enjoy that company, such as a pension or medical aid or time off or leave and so on. So really you find workers are being abused and employers are taking advantage of the fact that we have 40% unemployment and workers are thus desperate for any job and will often sacrifice their own rights simply just to get a salary at the end of the month.
All right, let's leave it there for now. Namhla ke babukeli sikhuluma ke ngekucilateka noma ngekuphatheka kabi kwetisebenzi baqashi babo. Let's now take another break. Kungasanyaka siyabuya khona nyalo. Siphinde samukele ke babukeli tincingo tethu tivuliwe kanzi ke nawe ungasishayela licingo ke ku-0117146918 noma ke 0117146919. Do you have any thoughts to share with us on how you prepare for your case to be mediated at the CCMA? You can also SMS your views to 33721 or catch us on our social media platforms. And speaking of which, we've got a couple of responses on social media. Let's take a look. Tebogo Utsi, if one works on a contract basis, there's always that abusing which will take place and be swept under the carpet, a sad reality. Aida Utsi, from the cases that I've seen and heard of, no one ever got their fair outcomes from CCMA. They are somehow and slowly failing the people. Do you agree, Mr. Mason?
To by and large, yes, to a large extent, because when we look at the enforcement of the orders, of the CCMA, the rulings, the orders, is that it's a cumbersome process to take those orders and certified by the director of the CCMA, and then for you to issue a warrant to attach the properties of the employer, and also the issue of referring the matter when you get an award, referring the matter to the Labour Court in terms of section 1581C. In terms of making that order an order of court, the CCMA award, an order of court, so you can get a writ of execution to go and attach the employer's movable or immovable properties. So we are saying that it's difficult that the workers would try and enforce this particular award that has been given to them to that extent.
All right, let's take our next caller. Sina Susan ulapha ke Brits. Sakumole hleleni sawubona.
Ki mo Brits na ke bereka sa profiling. Ke tsame Maseng.
Susan from Brits, welcome to the show.
Yes.
What's on your mind, ma'am? Yeah, please go ahead. Yeah, go ahead.
Okay. Ne ke bereka ko SS profiling. Ka di 3 le di 4. Ke ile ka kopa ke ya Lusung Petersburg 345. So ba ndumella makhuwa ke bua ka bua ke ntse ke kopile copy ya certificate. So ba mpha warning form ya gore ke hearing ga di 15 ba mpha dismissal ba go ba mereko ba mpha some former million telephone consumer company online personal account 156 499 modimo 156 499 mampile 8,300 and something ke ka mo ke ile ka ko SABC wa Yilungelo Lakho ke gopele thuso ka obane CCMA ke ile aki ya morao reunion ne ba ntwaleletse konde ba sanya go nthusa CCMA ba mpotsa gore bona ba ka se khona nthusa ke tshwanetse ke thuse ke union ya ka ya NOMSA. So ka ya ko di officing tsa union ya NOMSA ka ba tlhalosetsa re ke ile kwa ke date ya ka ya tseko wa ile ntsha case ya ka le sample le ba case ya ha o to thusa ke rena ka rena ro hela tšhelete ya ha ko payslipping case ya yo sekelwa ko NDC re ile kgwedi ya mathomora ya bobedi ya boraro ke tshwere di receipt tsa bona mo ya boraro ke ile gore ba re nna ke signele 5,000 case fele ke tšhelete ene ke ntse ke namela ka yona ke e senya ke ka mo ke ile ka bona gore ke tle ko Joburg.
All right, Susan from Brits, thank you so much for your call. We've got a Labour lawyer here in studio and as well as Kosatu that might help you out with that. All right, we'll certainly get to Susan's call in a moment. But Mr. Parks in Cape Town, I just want to pick up on that comment that you made earlier on with regards to contract workers and contract, seasonal and permanent contracts. So what if a company gets an evergreen contract from wherever, but then the nature of the work is short-term, is seasonal? So the employees, should they be given contracts still, or permanent contracts?
Look, it depends on the nature of the company and the nature of those positions and the contract. So look, if it's a short-term contract, as the law provides for, you don't need to make the person permanent, If it's a simple 2-month activity, short-term contract, it's fine. But what you have is you've got mainstream companies which have got permanent businesses operating, positions are permanent, like in the retail sector, we've got cashiers. Those retail sectors, the shops are there permanently. It's not a once-off activity. They're there 12 months a year, year after year. And the very same jobs of cashiers, of cleaners, of security, of shelf packers are permanent. And the very individuals occupying them are there year after year, like the woman from the Val who was there for more than 2 years, yet she was on contracts. So that's really an abuse of the system. The Labour Relations Amendment Act says you can be permanent for up to 3 months, then you must, contract up to 3 months, then you must become permanent. If an employer can show that that's a temporary job, they can apply for an exemption and they'll be granted it if they meet the requirements. But what you have really at an increasing level across the retail sector, especially but in agriculture, in hospitality and transport, is that permanent jobs are being made temporary contract work. You also have a new trend in the financial services sector where they call you a self-employed, that you are a sales agent, they now say you're self-employed, or that you're in the transport sector, you're a truck driver, they call you an owner-operator. It's really English gymnastics. You're still a worker, but they just made you pretend that you are self-employed to avoid the obligation of the employer having to make you permanent, and also for a way for them to suppress your wages, to not pay you pension or medical aid or 13th check and so on. So really it's an abuse of workers, and right now about 1 million workers plus on this kind of a scenario where they're permanently temporary workers.
So, Mr. Parks, what do you think is the role of the Labour Court, or what should be the role of the Labour Court with regards to cases that have been referred to the CCMA?
Look, we need to overhaul the system. The system right now, where most workers are not aware of the CCMA or the Labour Court, it needs to be addressed through education. Workers need to join unions. Only about 1/4 of workers belong to trade unions. That's a key weapon for workers to protect their rights. Equally, the CCMA needs to be given more financial support and more resources, and its decisions need to be made binding and implementable. So the Act has to be amended to make the CCMA decisions enforceable. The Labour courts also need to be overhauled. The Labour court judges need to be given further training so they really understand the full progressive nature of the labour laws, but they need to be better resourced. You can't have a scenario where Labour courts take 2 years to process decisions. They need to find a situation where free legal aid is given to workers, so they don't need to spend huge amounts of money on legal representation. So it really needs a massive overhaul, and that needs to be dealt with by Parliament and the Department of Labour. Equally, the Department of Labour needs to overhaul its labour inspector regime. They've committed to employing additional 200 labour inspectors this year, but they need to have a much more progressive kind of proactive enforcement of labour rights. They've promised to us to set up a toll-free hotline where workers can SMS the Department of Labour when their rights are being abused. That is to be unveiled by January this year. And there really needs to be a much more kind of proactive engagement by the Department of Labour to make sure workers' rights are enforced and protected across the nation.
All right, thanks for your thoughts, Mr. Parks. We'll take a final break now. Welcome to our final segment. Saqhubeka futhi ngenkulumo yethu ngekuhlukubetheka kwetisebenzi njengoba namhla ke celebrate i-Day of Reconciliation lapha eMzansi ke. Now, Mr. Mason, I want to take you back to that caller, Susan from Brits. She was basically saying that she was unfairly dismissed, and the CCMA ordered that she be given 160,000 rand, but then the company gave her only 8,000 rand, and the CCMA said that she should go to a union for recourse or for further assistance. Will a union help in this instance?
No, I think that she was misdirected by the CCMA. That's what I'm saying. If you don't have confidence in the CCMA, you can be able to take that order, that arbitration award, and take it to the Labour Court in terms of Section 158(1)(c) to the Labour Court to enforce that particular court order. To make it a court order, so you can be able to then execute, and you can be able to get a writ of execution by the registrar and try to enforce to attach the particular movable properties of the employer for that particular value.
So what should she do?
At this current instance, because I'm saying that we're looking at prescription, it depends as to how long, when did she obtain this particular award, because in terms of law prescription, your claim also prescribed after 3 years. So if the claim is still within the 3 years, she can be able to then approach the Labour Court to try and convert that particular award into an order of court.
Okay, so how would you advise employees to go straight to the Labour Court or start at the CCMA?
The CCMA, because all disputes need to be referred. That's why there's conciliation. So for the employer and employee to find one another. That's why the disputes get referred to the CCMA. You cannot jump to the Labour Court there, because then you will not exhaust all the remedies that are available to you. So you need to then first refer the matter to the CCMA, and then for conciliation, and then there will be a certificate of outcome, and then you can be referred the matter in certain instances to the Labour Court.
All right.
Yes.
Mr. Parks, as we wrap the show, how can workers better prepare themselves for cases which will appear at the CCMA?
Several things. One is they should join unions. Only 1 out of 4 workers belongs to a union currently. Those unions themselves need to merge together and unite, because currently we've got about 200 unions in the country, which is far too many. Workers' best defense is unity and organizing. Those unions need to make sure that workers are aware of all their rights, the technicalities and the spirit and objectives of all their rights under the different labor laws, from the labor relations to the basic conditions to the health and safety and so on.
So just how influential are unions then? I mean, we've just had a caller from Brits who's saying that the CCMA advised her to go to a union. So does the union wield significant influence in solving such cases?
It can often do so. Not all unions are at the same level, but often they can help to deal with issues before they even need to go to the level of CCMA or the Labour Court. If a workplace is well organized, those workers can give solidarity to prevent that worker from being dismissed or being victimized and abused. It really is a key tool for defending workers' rights and making sure the employers behave. It's a key educational opportunity. And look, so the best form of workers' defense really is the workers organizing themselves across the board.
All right.
Workers are able to show solidarity.
Okay.
And equally, it's important for those unions to make sure workers are aware of the avenues to protect their rights, from the CCMA to the Labour Court and so on.
All right. Mr. Matthew Parks from COSATU and Mr. Mason from Mason Attorneys, thanks to you two gentlemen for joining us. Much appreciated. Let me thank my guests today for making time to be with us. And the rest of the team, wishing you all a great festive season. Cheers.
Yilungelo